This is Jane Low, and I'm at TechLaw Fest 2024 here in Singapore. And with me today, I'm very pleased and very privileged to have Mr. Yeong, who is the Chief Executive with the Singapore Academy of Law, to share with us some of the highlights of the legal topics around emerging technologies of AI, of course, and also quantum technology. So thank you so much for your time today, King.
Thank you for having this chat with me.
Yes, so it's the second year in a row that we're having this conversation. And if you remember last year, we talked about also the topic of the AI and law as well. And we covered the topic of copyright. And we talked about the Jetty versus the stability case and how data lineage and later data provenance are very important considerations when it comes to these kind of copyright infringement disputes. And copyright is, again, a big topic this year from some of the panel discussions. And of course, there's also other emerging topics of transparency and explainability, which you also touched on at your panel yesterday, and also accountability when it comes to AI and law, right? Yep. And so we'll cover some of these topics. And of course, we'll finish up with some of the emerging sort of legal considerations when it comes to another important emerging technology, which is quantum.
Right.
Yes, so a lot of exciting topics. And of course, we're not covering everything today because it's impossible. There's so much that the conference is covering. So to kick off copyright, so since last year, there has been a few other cases, Jetty versus, I believe, Adobe, Jetty versus Shutterstock. And so there's a lot of versions and theories of copyright infringement when it comes to AI, using copyright images and articles. And so what are some of the, I guess, lessons we can learn? Because there's, over the last 12 months, there's so many sort of arguments about, fair use versus scraping data and making copies for training, right?
Well, I'll say that the litigation cases are still ongoing, so there might be more cases that have been filed trying to test the boundaries of fair use. I don't see any clarity on those principles just yet. There are more cases for sure. More cases have commenced, right? But none of them have actually reached trial. Some of those cases that we looked at last year, they've reached a stage, what we call a dismissal of claim stage, where some of the claims that are weaker, some of the U.S. district judges have said that some of these claims, they are so weak, I will dismiss them so that you can concentrate on the core issues. So the core issues around fair use, those are still making their way slowly towards trial. But one of the things that has come out in the last year, which is very interesting, are some cases coming out of China. And these are cases around the question when you use AI to generate new content, new images, right? When are they infringing, and when are you able to say that you actually have copyright in those? And you can contrast them to some of the cases coming out of the U.S., the U.S. Copyright Office, where they have said that if you're using generative AI to generate images and all you're doing is to provide prompts, there have been a number of cases where they say that that kind of copyright content cannot be registered by the Copyright Office. So two very contrasting approaches. Let me explain them in a little bit more detail. So from what I gather, the U.S. Copyright Office approach treats the language model, the generative AI, as though it is an agent. And your prompts are instructions you're giving an independent agent. So which means that your prompts will not be sufficient to get you, right, the person who gave those instructions, copyrights, because the agent is the one that has copyrights. And since the agent isn't the person, right, they can't have copyright. So that's been the position of the U.S. Copyright Office in a couple of cases. Contrast with China, where the Chinese courts, again in a number of cases, right, have essentially listened to the claimant. The claimant was able to demonstrate the prompts that he gave to the generative AI solution, and he was able to show successively how the image was transformed with each successive prompts, such that he was able to then demonstrate that the prompts were in accumulation, sufficient creativity and originality, so that the output of the model was copyrightable, and the person who provided the prompt can gain copyright. And the Chinese courts have actually upheld a copyright in a couple of these cases.
So it's on a case-by-case basis to the extent that you can prove that there's a substantial amount of creativity process behind
Yes.
The whole sort of value chain of generating that image.
Yes, and it really it conforms to the first principles, right? The first principles of copyright is that it protects expression, it protects creativity, it protects original ideas, and if you're able to demonstrate that the prompts are essentially original ideas and expressions from you, and these are translated by the model into an output, and you're able to demonstrate how these prompts influence the output, then you're able to show that it is your creativity that originated from you that is the cause, right, of these outputs, and hence you own copyrights in those.
So in this case, in the Chinese case, is it an article or is it an image that was?
It's an image.
Okay.
It's Chinese name, Liu versus Liu, right?
Oh, right. Okay.
Yes, yeah. So it's essentially about an image of a Chinese model.
Right, okay. It's quite interesting to see whether it can be easily translated to, say, creative works of word, like poems or, articles, because...
Yes. We have to see, right? Yeah, but I can imagine that might actually be possible.
Yeah, and it will be interesting to see how that differs from country to country, language to language, right?
Yes, and this is still an area that's still under a lot of debate, and there will be continued evolution. Just at the corridors of the exhibition today, I heard that apparently the US Copyright Office might actually be relooking at some of their guidelines. Who knows, right? So I think this is a very exciting area. We're very, very early stages yet in this whole area of development. Very interesting times for TMT lawyers.
Yeah, absolutely. I was just going to say, last year when we had this podcast, we talked about, how job security was one of the top concerns. But this year, it's sort of fade away, and it's a lot of excitement about how AI will help the lawyers, be a complementary tool. And in fact, it will add a lot of, concerns for, the wider public to really approach lawyers to get some legal advice to settle some of these.
Yes. I think that we have come a long way since our conversation last year. What I hear a lot in the exhibition hall when we're talking to people is that they are interested to embrace AI and to find the right tools to help them be better lawyers. And one of the things that I've been sharing with people when they ask me whether AI will take away the jobs of lawyers is that AI will not take away the job of a lawyer, but a lawyer who knows AI will take away your job.
Oh, yes, yeah, that's right.
And that's really the emphasis this year. One of the things that SAL did is to work with our community of volunteers and also with Microsoft, right, to develop a prompt engineering guide. So generative AI tools are on the desktop of all lawyers in the form of Copilot, which is integrated with Microsoft 365. You can access Claude, you can access OpenAI, ChatGPT, you can access Gemini. So these are general purpose chat-based generative AI tools. So our prompt engineering guide is intended to teach lawyers how to use them in the right way and use them effectively to help with legal tasks so that they will be the lawyer who knows AI
Yes.
And will not be threatened by AI.
So when we talk about some of these tools to help lawyers, right, there's an essential element of, I guess, accountability, human in the loop, right? And there's always a bit of a trade-off, a tricky trade-off between productivity gains versus safety. And it's always quite difficult to actually determine the kind of thresholds and decision trees, to be built to incorporate this human in the loop process. So what have you seen so far? There are some of the challenges.
Well, I would say that in the context of using AI in the legal space, or by lawyers when they are providing legal advice and professional legal services, our stance is definitely human in the loop. I have two examples of how we take this principle and we apply it in our practice. So, for example, our prompt engineering guide, right? It is a repeated exhortation in the guide to say that always remember the professional responsibility a lawyer has to his clients. Always make sure that you use the tool to help you with tasks. Always apply your domain expertise, your specialist knowledge to the outputs. Check, verify, integrate the outputs into your final work product. You are responsible for your final work product. Definitely human in the loop, right? The other example that I can raise is another way we put this in practice. We just launched LawNet AI, which is an AI tool that is integrated with our LawNet legal research portal. And we have implemented the ability to use generative AI to create summaries of cases. Now, creating summaries of cases is a very established and very stable use case for generative AI. So we spent, half the time training and fine-tuning our model using our law reports, but the other half the time, we built trust and safety features. Things like highlighting probable hallucinations, highlighting sections in the summary, which is of low confidence because the same thing isn't really quite found in the source judgment, and then also highlighting each paragraph of the summary to the source paragraph in the judgment. Now, these are tools meant to assist the human reader. So again, definitely human in the loop. In fact, tools to help the human perform his work well when he is in the loop.
Right. Basically, we can outsource some of the tasks, but not the responsibility or the accountability, right?
Yes. The tool helps us with some of the tasks, right? It can make it a little bit simpler, but we're ultimately responsible as professionals.
That's right. Yeah. So coming to accountability, and another, I guess, two aspects are explainability and transparency, which you also touched on your panel yesterday. And if I may turn to this EU AI Act, right? And we also spoke about it last year as well on how some of the high-risk AI users need to have this clear and comprehensible, I guess, explainability element, right? And yesterday at the panel, I get the sense that the scope of what explainability and transparency means is still very undefined yet. It's still kind of work in the progress, right? So what are the challenges you see in that space based on your observations from the panel and, of course, your observations from speaking to your peers? And what personally would you like to see when it comes to some of these high-risk use, like, for example, in medical or healthcare diagnosis?
Yeah, so I think one of the things that we discussed in the panel yesterday is the difference between transparency and explainability. And a very easy way to tell them apart is transparency is about all the steps and all the inputs, like training data, that went into developing the model that was eventually tested and then deployed. So it's about how you built it. Explainability is about why this particular output was given to you. Why do you experience this particular output from the model? So it's a lot more specific to one particular interaction and your experience with it. So the EU AI Act focuses on transparency. it requires transparency in various stages, right? It doesn't go quite far as to say that you must have explainability.
Oh, right, okay.
Yeah, because explainability is still a bit of a challenge to achieve in today's science. So that's the distinction. But moving away from what the law requires, I think it is important for us to understand why we need both and why we should strive to achieve both. The transparency makes it easier, as one of the speakers at the panel said yesterday. With transparency, consumers and users will have access to the information that they need to enforce their rights. Explainability, to me, achieves a slightly different goal. Explainability achieves the goal of building confidence and trust. Because if I understand why this particular movie is recommended to me, if I understand why this particular song is recommended to me, I will trust the service more, and I will tend to use it more. And if I don't like the particular recommendation and I'm given the ability to influence it, then I might do something so that I can use the service more. So two very different purposes served by these functions, but it is important for us to work towards achieving both.
So what you're saying is that the EU AI Act has not really delved much into detail in terms of the explainability requirements.
Based on my recollection now, explainability is not a requirement, but there are very specific requirements for transparency.
Right, okay. Obviously, I guess from a commercial point of view, it's in the interest of business enterprises who use these AI systems for the consumers to have that explainability part in order to build trust with their end users, isn't it?
Yes, and I think we can see that happening even on a voluntary basis in a lot of the services that we use. Many of us watch movies on OTT services, right? And very often they recommend based on what you've watched before.
That's right, yeah.
And they recommend based on what you have responded that you like, right? So by letting you know that because you've watched this, hence I'm recommending these others, because you've thumbs up, right?
Yeah, that's right.
Certain things, then I'm recommending others. It gamifies it. It encourages you to give more responses, thumbs up, thumbs down, right? And it encourages you to use that feature. So you take this logic, apply to shopping carts, e-commerce marketplaces, right? Yeah, and I guess these days even advertisements.
Yeah, that's right.
Yeah, they're starting to show you why this advertisement is being shown to you and allow you to basically interact with it. And I think that by doing this, it's I would say explainability in action, and it definitely drives positive interactions with between the service provider and the end user.
Yeah, I'm thinking like sometime in the future when we actually have direct access to some of these health diagnosis portals, right? We would want to be able to say, okay, you know, the medical report that I get, is it false positive, is it false negative, and I want to have some sense of explainability behind how that is generated by some of these AI chats, right? So I think that's quite far in the future. But
Yes. Yeah. I'm still quite hesitant to rely on the AI for health reports.
Right.
Yeah, I'd rather just have the test lab results and go see a doctor.
Right, human in the loop. Right, so I know that we have a lot of topics that we can cover, you know, privacy and confidentiality, also obviously very, very important topics for in the legal sphere when it comes to using AI, but I don't think we have the time to cover today. So I'd like to just jump to the last question, if I may.
Sure.
The legal sort of developments in the quantum computing space, because I think a lot of people have the sense that, you know, it's a lot of regulations out there that is sort of work in progress, a lot of guidelines, but there's no sort of overall sort of very hardcore sort of requirements yet. Is that a misconception or?
No, I don't think that they are wrong, because we had a chance to explore this topic. I think in summary, what I took away from that discussion is that quantum computing is already here, but not so accessible. It is very expensive, and its availability is probably to very large and well-funded banks. That was one example of where you might find some quantum computers, and of course research and government institutions. So not too many have access to it, but it is here. I think that the question that came yesterday was, when would it become more commercially available and more, in that sense, when would it be more commercially affordable, right? That might be 5 years, nobody knows, it could be a bit longer. The other thing that we talked about yesterday around this is that when that day comes, right, it will have some fundamental impact on certain assumptions that we've made today. And one classic assumption is that the encryption technology that we use today is computationally not feasible to decrypt, right, because it would take years. So we have made certain assumptions based on the science, and based on that, we've made certain policy decisions to say that, well, if you have encrypted data, then it is good protection, then that's fine. So some of the questions that we went away thinking about is, hey, if quantum computing might be able to decrypt this with ease in 5-10 years' time, then we might want to think about whether some of these assumptions will still hold true, and whether some of these policy decisions need to be revisited. But it was also counterbalanced by the fact that, you know, a lot of the data that we have today, the lifespan is short. The usefulness of the lifespan is short, may not be 5 years, right? But there are certain categories of data that is immutable and the lifespan is much longer. So those we might be a bit more careful about. So it's not a doomsday scenario. There's still a lot that we need to understand, both on the availability and accessibility as well as the impact. So the feedback that we got from the panel discussion was very positive yesterday, and I do intend to pick this conversation up again next year and dive deeper into this topic.
Yeah, it will be exciting to see, what is going to happen in 12 months' time, because so much has happened in just the AI space and law in the last 12 months, right? Speaking of which, also another emerging technology, which is blockchain, right? Which unfortunately I don't think we have the time to cover today, but hopefully we can cover next year in 12 months' time to see what's happening.
Let's see what's happening in the blockchain space as well.
Yeah, that's right. So a lot of exciting space stuff happening in law and all these emerging technologies. So no fear of job security questions and concerns, right?
Always enough jobs for tech lawyers.
Definitely.
Yes.
Yeah. So thank you so much, Yeong, for your time today.
Yeah, thank you. Yeah, thanks for having me on the show.
Thank you.
Thank you.